Hello and welcome. You're watching The Social Network. Now, the Supreme Court quashed the NEET eligibility test for medical colleges across the country. That was a big order yesterday, and of course, it affects thousands and thousands of students across the country who were very keenly watching, of course, what the Supreme Court would in fact rule on that particular case. But many are asking whether the government's attempt at trying to clean up the corruption mess in the medical education system has ended up, in fact, being unconstitutional. That's what the Supreme Court said. So that's what we discussed on The Social Network today. Common, not equal. Supreme Court bans the common entrance medical test. And of course, our Twitter ID is right there on your screens at the moment. It's at TSN on NDTV. You can tweet us live during the show. And of course, you're welcome to ask questions to the panelists who are joining us on the show. In fact, let's quickly introduce our panelists for the day. We're joined in the studio by Anup Surendranath, who's a constitutional lawyer. And we're also joined by Nidesh Gupta. He's the lawyer for the Medical Council of India. And we're also joined by Smriti Singh. She's a research scholar at JNU. And we're also joined on a video call by Tanya Ali. She's a medical student and she joins us from Bhopal. Anup, one of the things that's being said about this order, which, a lot of people on our Twitter timeline have, in fact, said that, they're disappointed by the Supreme Court order. But one of the things that's been said about the order is the fact that it's completely legally very, very sound. It's following the complete print of the Constitution in that sense. But it's against this. But the Supreme Court obviously said that the NEET is against the spirit of the Constitution. What does that really mean? Right.
The first thing to note is that, first of all, the judges deciding the case were not unanimous in their opinion amongst themselves as well, that there is a dissent by Justice Anil Dave in the judgment. But the majority, and I tend to agree with what the majority is saying, that it is unconstitutional in terms of the impact it has on the rights of minority institutions. And more importantly, rather than the technical point on how it impacts minority institutions, I think the Supreme Court is, the majority judgment is correct when it says that having a common test has a disparate impact on students all across the country, that a common test is problematic because we do not have uniform standards of education all across the country, and having a uniform test is in that sense arbitrary because it benefits a certain category, a certain profile of students, a certain profile of urban students who have had access to certain kind of education, and a common test benefits them. And unless we have common standards of education, and we don't have that, standards of education vary across the country, we really cannot go in for such a test. It is going to have the counter effect if you do, because you're just going to benefit a certain category of students.
Nidesh? I mean, essentially that's what the court is saying, right? That, of course it's a common test, which means it would standardize and make things a lot simpler in that sense, and also get rid of a huge amount of the arguments against corruption in the earlier procedure. But it's basically denying a lot of rights to people who don't have access to that kind of infrastructure to be able to actually compete, say, with me, for example, if I sat down in the test.
Now, this issue regarding a common entrance test is a matter which has been considered by the Supreme Court not once, but in a series of judgments, sure, and a series of Constitution bench judgments. In a recent judgment, in a relatively recent judgment, in the line of judgments considering this aspect, which is the P.A. Namdar judgment, the Supreme Court said that it needs to be specifically stated, and I have that quote here, that having regard to the larger interest and welfare of student community to promote merit, achieve excellence and curb malpractices, it would be permissible to regulate admissions by providing a centralized and single window procedure. Such a procedure to a large extent can secure grant of merit-based admissions on a transparent basis. This is in line with what a larger bench in TMA Pi had said some time before this judgment, and which had subsequently been reiterated in Islamic Academy's case. So what the Supreme Court said, and thereafter in the Constitution bench judgment, the Supreme Court itself went on to say that the central government, the Medical Council, should come up with regulations which will ensure one single entrance test which will eradicate or at least substantially remove the bane of capitation and profiteering.
Sure, which was essentially why the government and the MCI and the, put up this whole thing of the NEET. And of course, that was, like I said, the government's attempt at trying to make it simplified for students across the country and get rid of that huge amount of corruption problem in which we saw attached with the CET. But I think the focus of that judgment really is still on the fact that, it's standardizing is not actually providing equal opportunities to all the students. In fact, we're joined on the phone line, I'm going to come back to you, Nidesh, in just a second, by Sunil Chandi, who's the director of the Christian Medical College, Vellore, and he's in fact favored by that Supreme Court verdict. Sir, if you can hear me, what do you make of that order from the Supreme Court yesterday, quashing the NEET?
Well, we are very happy with the judgment, as this verdict protects our unique interests as an unaided, minority, charitable, not-for-profit, non-capitation fee college, which has had a track record in education, is an institute of excellence for the last 113 years.
But Mr. Chandi, if I could just, if I could just interrupt, of course, you are happy because this would give you back a lot of your autonomy, etc. But do you agree that, medical students in the earlier process were also having to do a lot of running around from one state to the other? I mean, it takes so many different types of exams and really having to run around a lot. And that's not really fun for the students either.
Well, I cannot speak for the other colleges, but I can speak for our college. We actually have a test which is conducted in multiple centers, and it is a national test which gives us the right to admit students which fit in with our vision and mission of training students who will go out into the far remote areas of this nation. This is a system that has been endorsed for its transparency, merit, non-exploitative, and the admission process is absolutely fair. This has been endorsed by the highest courts of the land.
Mr. Chandi, really quickly, what was your principal opposition to the NEET?
Our principal, the basic grounds of challenge to the NEET regulations by CMC was that being a minority institution, we are fully protected under the Article 30 of the Constitution, and that such protection has been recognized by the 11-judge bench of the Supreme Court. The NEET regulations, therefore, violates CMC rights under Article 30.